So good morning, good afternoon, good evening to everyone who is joining us for the webinar. Good evening, because we are sure that this is happening beyond the African continent. So we are very happy to have you on board. Welcome to the Center for Human Rights Talk series. Today we are focusing on the rights of the child, and on a very special occasion because today is the Day of the African Child. And so we are having our reflections as guided by the Day of the African Child and the theme for that. We will get into a bit more of the details on that, but just before we get into the details, I would just want to mention a few housekeeping issues for us to keep in mind. One of those, for participants who are joining us, we would kindly request that all of us please turn off our microphones and cameras unless it's your turn to speak, so that it will allow all of us to follow the conversation and to minimize the disruptions. The second thing is to kindly request us to, or rather to ask that you indulge us. We will be administering a short poll, which is already on your screen right now. This is really just to engage our participants in the conversation. So please take a moment to fill in or to respond to the questions. Towards the end, we hope we'll be in a position to share with you the outcome of the polls. So kindly, as soon as you finish the poll, you can end it on your side. It will disappear from your screen. So today is 16th of June, obviously, 2020. And for those of you who are joining us from South Africa, it's a public holiday, it's Youth Day. And therefore, we sincerely appreciate your time because we know that it's a public holiday. For everyone else on the African continent, today is the date that the African Union has designated as the Day of the African Child. And so we are taking this moment to reflect on the theme of this year's Day of the African Child, which is access to a child-friendly justice system. Just a moment. This day was instituted in 1991 by the Organization of African States, and the assembly meant that we use the Day of the African Child to commemorate the 1976 student uprising in Soweto, South Africa. As most of you would know, it was during the apartheid, and students in South Africa took a stand against the apartheid regime, particularly in relation to education, demanding that their rights be recognized and that they be educated in their own languages. And those student protests became a very significant part in the contribution towards the end of apartheid in South Africa. So this is really the background. However, in modern days, in the form that the African Union has intended for the Day of the African Child, we use it as an advocacy tool to draw attention to the various issues affecting children in Africa. And so for this year, the African Committee on the Rights and Welfare of the Child has guided us to reflect on the theme of access to justice, and very specifically to reflect on access to a child-friendly justice system. So that is what we are going to be discussing in this talk. Specifically, we'll be discussing this issue against the background of, obviously, the ongoing COVID-19 pandemic. And so we are very conscious of how this is affecting us. So we will be touching on various issues on that. And secondly, also that this year is very special because it marks 30 years since the adoption of the African Charter on the Rights and Welfare of the Child. So we also have a moment of reflecting on the journey so far, but also the influence of the Charter on where we are heading as far as access to justice is concerned. To assist us with this discussion, I have a very eminent panel of experienced practitioners and advocates of children's rights, who I will briefly introduce, and then they will guide us in the conversation on the various aspects that we will be talking about. So I will start by introducing Lady Justice Maria Mapani-Kawimbe, who is a judge of the High Court of Zambia, and who has been a judge since 2016. Before that, she served as the Deputy Chief State Advocate in the Attorney General's Chambers and as a Senior State Advocate in the Office of the Director of Public Prosecutions in Zambia. She held various positions in the Ministry of Justice, including the Deputy Director of International Law and Agreements. Currently, Justice Maria is a member and the second rapporteur of the African Committee of Experts on the Rights and Welfare of the Child. She will be our first panelist. Our second panelist will be Professor Ann Skelton, who is a professor of law at the University of Pretoria and a member of the UN Committee on the Rights of the Child. Professor Skelton holds the UNESCO chair in education law in Africa, and she has engaged extensively with children's access to justice through research, advocacy, law reform, and litigation. She is a practicing attorney who, as some of you may know, has appeared very often in South African courts, arguing landmark cases that we have all come to refer to and have influenced jurisprudence across the continent. Our third speaker is Dr. Musa Chibwana, or Musa, as we regularly call him. He's a child rights expert with a wealth of experience spanning more than 15 years and has been working with both civil society organizations, but is currently based at the Secretariat of the African Committee of Experts on the Rights of the Child. Musa has experience and research interest in child rights governance, child protection in the context of armed conflict, and civil society in Africa. Musa is currently focusing on children in armed conflict as a senior child protection officer at the committee. So he has very interesting perspectives, particularly in relation to children in armed conflict. Our fourth speaker is Ms. Felicitas Motimedi. She is the regional coordinator of the Child Rights Network for Southern Africa, CRINSA, as some of us may know it. She's a human rights expert with a lot of experience in engaging in various sectors, including health, social development, gender and human rights, and also engaging with states and duty bearers, but has a particularly good experience with working with the civil society sector in relation to children's rights. And therefore, she will be providing us some insights in relation to how civil society organizations are working in this subject area. So this is the composition of our panel. I have no doubt that we'll have very fruitful conversations. So the format is, we will allow the panelists to speak, and then once they've had the opportunity to speak, we will then have, we'll take questions from the Q&A, as well as some of you who may be in a position to communicate through the chat, and then we will have a discussion thereafter. And just before I hand over, just to mention also that today being the Day of the African Child, we have a lot of events happening around this theme. And one of those is that the African Committee of Experts will be hosting a commemoration. And so once we are done with this, we can also just encourage you to join the ongoing, or rather it will just have started, commemoration by the African Committee of Experts at the AU. Obviously online, but you can join as well. So thank you very much. And without much ado, I would want to invite Justice Maria to please lead us on the conversation on access to child-friendly justice. Justice Maria, we don't hear you.
Yes.
Okay.
Can you hear me now?
Yes, we hear you.
Can you hear me now?
Yes, we can hear you. Please
Yes.
proceed. Okay.
All right. Good morning, and thank you for inviting me to be part of the panel for this webinar. I would like to address you on the issue of access to justice from the committee's perspective, and maybe also give very broad insights on what the experience has been in terms of our quest to promote access to justice through the state reporting mechanism, communications procedure, as well as what we have also gathered from the different reports that we have dealt with as a committee. Having said that, the provision that deals with access to justice, if you like, is really restricted to Article 17 of the Charter, and in particular focuses on juvenile justice. And what that article provides for is that, especially as regards children in conflict with the law, that they must be given special treatment. And in this regard, it's important to recognize that emphasis has been laid on ensuring that their fundamental rights and freedoms are respected. What does this mean? Because this is quite broad. It means that, firstly, there's a prohibition on torture, inhuman or degrading treatment of children in detention, meaning that they should not be exposed to treatment or punishment that violates their human dignity, and also that they should be afforded chances or opportunities to go to court at the earliest that they are detained by the authorities, law enforcement officers to be specific. And in so doing, there's a presumption that they should be they should be presumed innocent until proven guilty, but this would depend on the type of system that a country subscribes to. But in most of the systems that follow a common law approach, the presumption of innocence, even for adults, takes precedence. Also, there's a requirement that in terms of Article 17 of the Charter, to deliver a charge to a child in a language that they understand. In so doing, every opportunity should be taken to provide for an interpreter, or if not, other means by which a child can actually understand what they're facing. Then there is also a requirement to provide for legal aid or assistance to children who are in conflict with the law, and also to ensure that trials that are taken are speedily conducted and the outcome known to a child as soon as possible. In terms of passing sentences, the article focuses on the aim to reform, pass sentences that aim to reform a child or rehabilitate them, and finally to reintegrate them into one's family. So here we are not looking at punitive sentences or using those sentences to make sure that they're excluded from their family environment. As much as possible, the sentence must reflect the best interests of the child, in that they would now, be taken, rather they would ensure that family disintegration is the last means of resort. Then what is worth emphasizing is that the Article 17 prescribes to member states that there should be a minimum age of criminal responsibility, and the death penalty should not be passed or capital punishment should not be imposed on a child who has even committed a serious crime such as murder. Now, in terms of promoting the right to access to justice, if you will, the committee has a designated special rapporteur on child justice, on juvenile justice. And in 2018 developed guidelines on child-friendly justice, which reinforce the provisions of Article 17. And some of the main highlights in that, in the guidelines, is that there should be a focus on, the focus in terms of judicial administrative proceedings should make sure that the best interest of the child is undertaken. And in this regard, one of the fundamental approaches is that the views of the child should be heard by a court or administrative body, and when sentence is passed, a judge or a magistrate or an adjudicator must ensure that the views of the child were taken into consideration. Then in terms of other mechanisms, as I said, available to the committee, I hope you can see me because I have a caption here that my internet connection is unstable.
We still
see me? Okay.
Yes, we see you.
Is the promotional activities that we undertake through the state party reporting procedure. When we have those dialogues with state parties, we actually dedicate quite a number of questions to juvenile justice. And also in terms of the communications procedures, we have had quite, not really remarkable, but perhaps 15 or so communications in which children's rights or perceived violations by states have been brought to our attention through the communications procedure. And there are one or two specifically dealing with issues of access to justice. And this, I think, involved a case where a child had to undergo a certain criminal procedure, but could not exhaust it locally because the procedure was unavailable in that state party. Now, what is also common from the state reports and the information or other sources that we deal with is that the emphasis in terms of child justice is really on children who are in conflict with the law. And yet the issue of access to justice is broader because it also has an informal element. And you note that from Africa that quite a number of children who grew up in rural areas are actually affected by the informal means of justice and not the formal ones. In terms of the formal justice systems, as a basic minimum, most states have provided procedural guarantees in terms of due process and right to fair trial. So when you're looking at the law on the face of it, it will look adequate, but it's the practice of the law that challenges exist. And now I'm speaking in my capacity as an adjudicator. What will apply also is that there are a lot of different standards. And what would be, for example, acceptable in country A as the minimum guarantee that a child has to go through will not so much mirror in different states. And also the law itself is not child friendly. Most of the legislation is constitutional and it covers adults and children alike. So you'll not really find those child-friendly procedures where children actually have a catalog of how they can actually access justice in a formal structure. Some of the challenges also are that the law regarding criminal responsibility in some cases is below the threshold prescribed in the charter. And it's common knowledge that in my country, I'm Zambian, that the criminal responsibility age is 8, while the charter prescribes 12 years. So you can imagine at that low age, a child being separated from their family environment. What is also common, at least, is that the imposition of capital punishment has been seldomly used in Africa, but there are few countries where, and the committee actually got involved. I think there was a case in Sudan where they wanted to commit a young person or sentence a young person to capital punishment. Also, it's important to note that access to justice does not really just start and end in court. It starts in terms maybe for children who are in conflict with the law from the time that they are picked up by the law enforcement agents, where they are kept, the facilities where they are kept, what sort of procedures are explained to them, and before their cases are processed in court. So you might find that even at a point where a child has been detained, that there is no designated juvenile correctional facility for such a child. They will be mixed with adults. And where they're even charged with adults in criminal offenses, you'll find that they're actually treated like adults. So if a case, depending on the turnaround time for case processing, if a case for an adult or adult offender takes 1 year, then that child would be kept, because he has been charged with adults, he would be kept in a juvenile facility or maybe even mixed with adults, depending on the situation. And in that sense, you fail to adhere, or rather states fail to comply with the requirement for speedy dispensation of cases. What is also a challenge is that we are focusing more on juvenile justice, and impliedly that involves children who are in conflict with the law. But then what is happening and what is not being addressed, at least on a small scale, is the children who are actually trying to access informal means of justice. And because of our African system, where we have a lot of people who are maybe under chiefdoms or traditional rulers, you'd find that there are more disadvantages for such children in terms of cases to do with inheritance, succession, or other informal means of justice that they would have accessed. Now we have also got children who are without parental care, and they would also like to access the formal justice system. But then again, depending on where you are and how quickly you can access legal aid, assuming that you do not even have any person, or you're really out of care, so there's no adult relative, or there is no one who can represent you in court, and you do not even know how to access the opportunities to access justice through legal aid or legal representation or any other form of representation, you'd find that these children are left out. Also, administrative systems are not truly assured, in the sense that, well, they are ombudsmen or I don't know, ombuds body, because it really depends, and I do not want to stereotype the description to a man. The thing is that they, at least where I come from in Zambia, the number of cases that have actually gone to the attention of that body and processed is not convincing. There are very few children who you could actually say access that facility. One, because it's also centralized. It's maybe there at provincial level, but the people who are affected and would want justice at that level could also be lodged in rural areas. And because of the limited information, maybe also limited education opportunities, they might not be able to access that office. Now, what I'd really, and maybe perhaps what I'm driving at, is that the bottlenecks in terms of access to justice are easily documented and traceable in the formal justice system. Whereas in the informal justice system, there is still a lot that has not been developed, and there is still a lot that should be developed. When a case comes to court, and if you allow me now again to speak as someone who has had the privilege of listening to some of these cases, you would find that some of these children do not actually know why they're in court. It means that the procedure, therefore, is not adequate. The process by which they have been brought to court, because they are just carried by law enforcement officers or correctional officers and brought to court. What the court would also place reliance on in certain circumstances is a social welfare report, meaning that in practice, the best interest of the child in terms of their views being heard and also their views being considered is not taken into account, because the person who would be mitigating on behalf of the child is someone other than the child themselves. So there's still a lot to do, at least at a continental level. In most country jurisdictions, we all agree that the due process of law and procedural guarantees on a right to a fair trial or to due process of law are established. What remains the challenge is how these children continue to access justice. And this is why the committee felt that access to justice should be the priority theme for the Day of the African Child this year. There are still more opportunities in which we can strengthen the situation of children in terms of accessing justice, but by and large, the frameworks that exist, be they legislative, administrative, or other, are not child specific in most cases and are not child friendly. Thank you. I'll end here for now.
Thank you very much, Justice Maria. I hesitated to stop you because I think you highlighted some of the very key issues that we are going to be hearing again in the course of the conversation from the other panelists. And so yes, I think without wasting so much time, maybe just to bring some of those issues without elaborating on them, I hear you talking about issues to do with availability of representation, about our knowledge of what is going on in the informal systems, about how in practice we actually cater for children, particularly children when they're accused alongside adults. I also hear you speaking specifically on the lopsided attention to juvenile justice, as opposed to the holistic aspect of access to justice for children that sometimes is not restricted to criminal justice. And yeah, so those are just some of the issues that I've noted, but which I think will come back when we start having the general discussion. And please, I would invite you to pick it up from there.
Thank you very much, Nkatha, and thanks for the opportunity to be celebrating this day with everybody and this important theme, which I think is really a very timely theme for the African Committee of Experts to have taken up. I'm going to talk about the what, how, where, and who of access to justice for children. If we ask ourselves the question, what do we mean by access to justice? We can break it down into, first of all, the idea of access. So how do children get access to justice? And two ideas. The idea is that they're in justice systems already because they're criminal proceedings or, sorry, Nkatha, did you want to speak?
Sorry, and just, I think there's something with your connection. It's breaking up. I don't know if you can stabilize it, if there's something.
I don't know. Let me just check if it's any better now.
That's clearer. Thank you.
Okay. So one of the things that we have to think about is if they're already in justice systems, are they really getting access to justice given the way in which the courts are working? But there's something beyond that, which is, do they have access to take up issues that are children's rights issues with the assistance of civil society or lawyers? And I'm going to return to that when I talk about the who and the how. The child-friendly justice, which is part of what the African Committee has included in their theme for this year, and is of course a lot to do with the way in which justice is delivered in the courts. So it's to do with making sure that it's a listening environment, an appropriate environment, that procedures are sensitive to the fact that they need to serve children, and also, of course, the fact that if possible, the spaces can be adjusted to be more appropriate. And then also the word justice. What do we mean when we talk about justice? So it is, of course, ensuring that there are just processes, that there are fair outcomes, but it can mean something and should mean something bigger than that. And that is access to social justice. So we can start to think about justice in the courts as a vehicle for children to be able to achieve all of their rights. And it's not just their civil and political rights that we need to confine ourselves to. We can also think about their economic and social. I'm sorry to
interrupt you. We still have an issue with the connection. I don't know what, I don't know if there is a place where it's, you know, or maybe it's not very strong.
I have one other possibility, and that is I could try to use earphones to see if it makes it better. Shall I try?
Yeah. But just close down the video. Just close down the video.
Uh-huh.
Will it stop? Okay, let's see.
Is that working better? Do you hear me better now?
We hear you.
Great. So essentially then, justice can mean more than the way that we tend to think about it, which is court processes. It can actually mean achieving rights, using the justice systems to achieve a broad range of children's rights. I'm pausing now just to check to see whether you can actually hear me.
And I don't know if we've lost you. We don't hear you now.
I'm going to try with the microphone.
Yes, please, if you can.
Is that any better?
Yes, we hear you. I think we hope it will be stable.
Right, let's see if it's an improvement with the microphone.
Yes, please go ahead.
So I've finished talking about the what, and I'm moving on now to the how. So how do we do this? How do we achieve this for children? One of the ways is to ensure that we train everybody who works with and for children so that they know how to work better with children in justice systems. It's also important to try to equip courts and processes to be more child-friendly, and that can sometimes mean physical equipment, but probably the most important thing is ensuring that all the staff that work with children understand what being child-friendly means. Creating spaces that make children more comfortable can also be a useful way of producing more child-friendly justice. But perhaps the single most important thing is to listen to children, because that is when we really become child-friendly. And as much as I think training is important for officials, including judicial officers who need to listen to children, even just listening to children with an untrained ear can make a very big difference. So changing laws to ensure that children have the right to speak and must be encouraged to speak in all interactions with the justice system is really very important. And I think when we think about access to justice, we should think about empowering children so that they know what their rights are, so that they can think themselves about how they can ensure that their voices are heard and to put forward their views, which of course must be taken into consideration. Then the where does all of this need to happen? Well, it does need to happen from the very, very lowest level of our justice systems, and it must rise all the way to the top of them too. So, for example, we've already heard Lady Justice Maria talking about informal justice systems, and it is challenging to think about how to make those more child-friendly spaces, but it is work that in Africa is essential to do. Also at the magistrates' courts, which is actually the place where most children will end up going, it is very important. But we again should think about those higher courts, the high courts, the Supreme Courts, the constitutional courts, where children's access to justice can be expressed through bigger, more strategic litigation that can achieve many of their rights, including the right to have more access to justice. So through litigating, we can also do something about the barriers that we may see in access to justice, such as children's standing, children's ability to bring cases and such matters. Also, of course, the regional level is very important, and we've heard something about that from the previous speaker, that the African Committee of Experts does receive communications and has acted on those, and so provided access to justice for children. And of course, at the international level, there are also various treaty bodies that receive communications, including CEDAW, the Committee on the Rights of Persons with Disabilities, the ICCPR Committee, the Human Rights Committee, and the Committee on the Rights of the Child. Although it's true that not many African countries have ratified it yet, so this would be a good moment to put in a plug for that. Fortunately, the African Charter has the major benefit that the communications procedure is built into the Charter itself. So that's a celebratory point that we can reflect on. But it would be great if more people would think about using that mechanism. And then finally, the who. Well, it's very important, of course, as I've said already, that everybody who works with and for children needs to be trained to work with them more effectively, to understand what access to child-friendly justice means. Lawyers are important role players in all of this because they know how to use the courts for the benefit of rights holders, including children. So their training and their thinking about how to use the courts more effectively for children's rights is very important as well. And legal aid is important here. Paralegals, all of those role players can do more to provide access to justice. And then finally, the most very important feature are children themselves, who must know their rights and feel that there is space and opportunity for them to access justice if we are really going to see the benefits and fruits of access to justice for children on the African continent. Thank you, and I'm sorry about the difficulties you had in following me.
No problem, and thank you very much. We sincerely appreciate those highlights. I think it helps us to be very clear about the what we are actually asking in terms of what is that child friendliness that we are seeking in this conversation, but also just what can be practically done. Who is it that we need to target? Who are the people that we are talking about, the stakeholders? And I believe that you will have maybe plenty of questions coming up in the follow-up. So I will again not spend too much time to highlight on it. At the moment, I would want to hand over to Musa, who will be guiding us on children affected by armed conflict. And then, yeah, we will come back to the discussion. While I'm at it, I would just want to reiterate again for everyone on the call, the participants, to kindly mute your mics so that we can minimize the disruption during as the speakers, the panelists are speaking. Thank you very much. Musa, please.
Thank you, Dr. Nkatha, for the opportunity and for organizing this webinar on this special day for African children. It is a special day, perhaps maybe to commemorate, celebrate, and reflect. I think I'll do the latter in my presentation. And also, being the male panelist only, I appreciate the privilege of being that. As we commemorate the Day of the African Child, I think there are two things that I want to reflect on pertaining to what happened in 1976 before I go to the issues I want to talk about. The first one is the issue of, I think Professor Ann Skelton has already talked about it, strengthening the agency of the children as rights holders for them to assert themselves to claim their rights. This is what we saw in Soweto, where children saw something that was an injustice and undertook action to correct what was wrong. That's the first thing. The second thing, as a takeaway from the reflections on the Day of the African Child, is the aspect of language. At the center of the protest was that Afrikaans had been introduced as the medium of communication in the education system. So I think my takeaway from this aspect is that as we reflect on child-friendly justice, perhaps we should consider how we adapt frameworks and models that may be global to our context to make sure that they are not alien, they are not foreign, they speak to the context in question, which is what the children of Soweto were reflecting on, to say, teach us in our own language. Perhaps let's do child-friendly justice cognizant of the context where this is happening. That said, I just want to engage at a conceptual level with the aspect of child-friendliness. I think building on what Professor Ann Skelton has already mentioned, I think there's a tendency to consider child-friendliness as a unitary typology. By this I mean there's a thinking that when we have put something in cartoons and have done animation, we have become child-friendly and we have reached out to children. It's not that unitary. The manifestation of child-friendliness should go beyond the cartoon, beyond the animations that we usually do when we want to say something is child-friendly. Of course, the principles have to be the same in terms of ensuring that the best interest of the best interests of the child are at the center. But child friendliness in itself should be diverse in view of the context in question. I think that is key to address, because children are not a homogeneous group. So child friendliness to one group of children is not child friendliness to the other group of children. There are children living with disabilities. So the child friendliness to children living with disabilities is not similar to child friendliness for a girl who is in a rural setting, who is suffering from many vulnerabilities. So as we reflect on this theme on access to justice, there has to be this unpacking of what child friendliness means to which children. Which children are we talking about? I think that's what I wanted to address. Then I'll go to the issues in question that I'm going to talk about. What does that look like in the context of conflict on the continent? I think just to set the scene, you are finding that on the continent, in all the 5 regions of the continent, there is conflict that is raging as we speak in Libya, in Mali, in Somalia, in the Sahel region, in Nigeria, in Cameroon, in DRC, the eastern part, northern part of Mozambique. I want to flag this one, in northern part of Mozambique, this aspect where the region is rich in oil, this aspect is, this conflict is missing from the media radar. So I want to highlight that. But one of the things that make all the issues that have been highlighted by the initial speakers, Justice Maria and Professor Ann Skelton, usually apply in an ideal case where the systems are in place. Of course, I know the Justice Maria mentioned that sometimes even in stable democracies, some of the systems are not in place. Legal aid is not available. The hard and the soft infrastructure to ensure child-friendly justice may not be in place. Now, let's put this in the context of conflict, where in some instances on the continent, you are finding non-state armed groups having effective control of territory. They do not put systems in place, so they use their religious persuasions and ideologies to administer what they would consider to be justice. And they will use these lenses also to deal with children. And this is one of the things that has to be flagged out here to say, okay, when we're considering child-friendly justice, the context of conflict is a different ballgame altogether. I'll use the case study of Dominic Ongwen to show some of these nuances that I'm going to highlight in the challenge of access to justice. For those who are not familiar with this case, Dominic Ongwen, according to the defense attorneys, to his defense attorneys at ICC, he was abducted or recruited to be a child soldier when he was 9 years old. Or some say 9, the other narrative is saying he was 14 thereabout. This already raises a key issue that we need to address when we are talking about access to justice, birth registration. Because this is key to the whole conversation about criminal responsibility. But in countries where there are no systems to ensure birth registration, we cannot ensure that child-friendly justice is dispensed on children, because there is no mechanism to judge whether this person is a child. So Dominic Ongwen was indoctrinated when he was 9. And he became a ruthless killing machine and committed heinous crimes. As we speak, he has 70 crimes that he is being judged for at the ICC. He rose through the ranks and eventually became a commander of the Lord's Resistance Army in Uganda. Now, on the 11th of March this year, the defense attorneys were presenting their case towards to the ICC, arguing that Dominic Ongwen is a victim, regardless of the 70 counts that he has of crimes against humanity and war crimes, where he also went further then to recruit children also. What we are seeing from this case is one thing. Number one, he did not have a birth certificate. So the argument that the defense lawyers are bringing up is that being also a victim, he committed these crimes when he turned 15, which the Rome Statute provides for criminal responsibility. When he turned 15, did that all change? Did the brainwash, the indoctrination change? In fact, he continued these war crimes even when he was no longer a child, which brings also the issue that we may have to grapple with as scholars, as researchers, and those in practice to say, on the spectrum of impunity and criminal responsibility or criminal liability for children, where should we lie? How should we ensure that children are dealt with as children, even though they may not have birth certificates? The other aspect is the issue of the sins of saviors. These are things that we are finding in conflict settings. There are two things that I want to raise on the sins of saviors. The sins of saviors are the troops that have gone to the countries to help maintain peace. And these troops sometimes commit crimes as well. What happens to those troops? What happens in cases of Somalia, for example? We have a colleague who is also an alumna of the center, Kabila, who is based there. They commit crimes and children are born out of this exploitation. The issue of statelessness for these children, because identity-wise, they look like where their fathers are from, whilst the identities of people in Somalia are different. How do you deal with situations of children who are born out of exploitation in conflict situations? It's one of the aspects that we're dealing with in the context of sins of savior. The other aspect is about collateral damage that happens. Of course, IHL accepts, or it's permissible to have collateral damage to gain military advantage. And sometimes children are killed in this collateral damage. I know the African Union, AMISON, has a standard operating procedure which provides for amends for children who have been killed or injured due to the collateral damage that has taken place. Now the question is, how much is enough compensation for a child who has lost their lives because of the sins of the saviors? So these are some of the aspects when we're talking about access to justice that we need to grapple with in the context of conflict. Then the issue of detention and the time frame. Of course, the principles provide that detention should be a measure of last resort. But sometimes logistically, it's not possible to have detention as the measure of last resort in the context of child-friendly justice. Because a child has been radicalized and has been indoctrinated, and before this child is released by the army or the military or the police, they have to screen this child to see the extent to which they had imbibed the doctrine of the armed group. Now that takes a lot of time. Sometimes, so the 48 hours or the 72 hours detention is not regarded because there has to be a lot of screening and a lot of doing of background checks that has to go on. Or sometimes the logistics of where this child has been kept at or where this child is surrendered to where they have to access justice is just sometimes difficult to do. And lastly, the issue I want to talk about is the reintegration of children in context of conflict. This is part of the justice spectrum that we're talking about. And when we're talking about the reintegration, this child has been recruited, has committed crimes within a community, and is going back to the same community because we want to make sure that the child is acceptable within the community. We provide this child with a lot of support. Other children are seeing this child coming with big cars of NGOs and is being given backpacks, education, everything, uniforms taken care of. What message is this kind of integration giving to other children to say, does it reward for one to join an armed group, then you can come back as a king where you are pampered. There has to be sensitivity of context when we're doing interventions that ensure child friendliness. So as I conclude, when we're talking about child-friendly justice, let's reflect on which child, so that we adapt the models, we adapt the systems to the various groups of children and the contexts where these children are located. As we talk about also durable solutions to issues of conflict, we have to address the underlying reasons why some of the children find themselves in conflict with the law, and why some of these conflicts, why children participate actively in these conflicts, sometimes voluntarily in courts. So this aspect is key to make sure that we consider reflecting on durable solutions. And lastly, I want to emphasize again the point of adapting our responses to the context in question without discarding the traditional justice systems. I wouldn't call them informal, I'll call them traditional justice system. I think highlighting also what the Lima Declaration on Restorative Justice says, which provides that we have to explore ways of building the capacity, like Professor Ann Skelton said, building the capacity of this traditional justice system so that they may be friendly to children. I think let me end here for now. Thank you, Dr. Nkatha.
Thank you very much, Musa. I think a lot of insights, and one of the key takeaways from your incursion into conflict is just to stretch. It has stretched the spectrum that we are speaking about in terms of the context of access to justice, to not just strictly remain within national courts and peacetime kind of access to justice, but for us also to open our minds to think about situations that are not the regular kind of situations where children would find themselves in need of accessing the justice system. But as I said again, issues for thought and issues to digest when we come back to the discussion. Before we do that, I would then I would like to invite Felicitas to give us a civil society perspective, and then we will get into the discussion. Felicitas, please. Felicitas, we don't hear you. Okay.
Hello. Okay. Thank you, Dr. Nkatha, and thank you to the university for allowing us to be part of the meeting. From the civil society organizations, we want to also congratulate all countries in Africa for recognizing this day and commemorating it. And we concur with the previous presenters that the theme for 2020 really is timely in the fact that we have been experiencing a lot of challenges insofar as access to justice for children is concerned. And as civil society organizations, our main issue really is that as much as civil society organizations are diverse in their makeup, what brings us together is the fact that we all are non-state actor organizations. And as a result of that, we complement government's effort in servicing residents in countries or citizens. We also do play a check and balance role where we sort of a watchdog organizations insofar as services are concerned. We monitor service provision, but we also analyze gaps that are existing in providing those services. And as a result of that, some of us are then involved in advocacy where we are lobbying and advocating for changes in relation to those gaps that would have appreciated from the ground. And we also do forge partnerships with stakeholders such as yourselves to ensure that we become efficient and effective in the interventions that we are providing. Now, as civil society organizations, if you look at the theme for this year, for instance, we do provide education and awareness in terms of rights, just understanding of rights for both children for the schools, for communities that the children are growing up in, as well as stakeholders, other stakeholders. And in instances where there are issues around safety of children, perhaps rights violations, we can move children from those violation places to places of safety, where we would provide shelter, food or clothing, but also document rights violations that facilitate for us to be able to do our advocacy role efficiently. We do provide legal services in some instances where firstly it's about literacy on the law or policies or things like that. We also do provide representation. Sometimes we're even forced to do self-acting coaching so that children together with their social workers as they go, they can self-act. But in other instances, we actually do have lawyers who can represent these children. In other areas, we actually do engage in strategic litigation where perhaps we feel that the issue at hand is an issue of national interest or continental interest, and that perhaps that particular matter would set a new jurisprudence insofar as the law is concerned. And as I indicated, we provide advocacy for policy change and law reform, where we feel that perhaps the provisions that we have are not rights-based insofar as their enforcement is concerned. And we can do that by analyzing these laws, by developing policy briefs that we then engage with policymakers, both technocrats and political policymakers, to make those changes. And insofar as today's theme and today's webinar is concerned, we are saying that the theme is timely, as I indicated, because access to justice for children has been a challenge in many African countries. And particularly, it has been a challenge because when you look at the different service providers that are working in relation to facilitating access to justice, you would find that very few of them are skilled or adequately skilled in dealing with issues of children. In some African countries, if you go to the police, where perhaps is the first point of contact in terms of reporting a matter, you would find that even the way that a child is being interrogated, it's in a way that can show that this child is being interrogated as if they are an adult. And in some instances, it's even boils down to intimidation, such that this child can actually mix stories or mix facts, and because of that intimidation, perhaps leading to their case being weak, or leading to their case not being substantive in terms of the merits. And then also, the service providers in some instances actually do use the African attitude or norm of being an elder as a service provider, and therefore being an elder, your role is to caution a child that if you can lie about this or if you can do that, this is what is going to happen. And that in itself then makes children to be scared and intimidated by the whole process. And because of that, we have found that children don't have access to justice, but also that there are not so many child-friendly justice systems that we have in African countries. If you can go around, as Judge Maria was talking about her experience as a magistrate, if you can go around African countries and check child-friendly courts, there are very few countries that are adhering to that concept of doing in-camera cases or facilitating sections within their courts to provide child-friendly facilities. And as civil society organizations, we really do feel that it is time that we address the long judicial processes, right from the investigation itself, where perhaps the police or the investigation officer is investigating to a point that a docket is passed on to the Directorate of Prosecution, to the involvement of social workers in terms of a social inquiry report, to the court date itself. In some instances in our countries, we find that some cases for children are reported when a child is 9 years old, only for them to be concluded when the child is now 19 or so. And they have forgotten all of those things, or we are reopening their trauma in terms of the issues that they would have suffered at that point. And the judgment itself then takes time. So these are some of the issues that when we look at the judicial process, we need to be taking into cognizance in terms of whether or not we are providing a child-friendly justice system. We also feel that we need to be addressing the root cause of children being in conflict with the law. Musa talked to some of those issues where there are conflicts because perhaps there's corruption, there's greed, and which is something that we find ourselves grappling with as African states, where, you know, the greed to amass wealth at the expense of citizens, and in some instances of children, really do lead to children ultimately being in conflict with the law, poverty being one of them, issues around GBV as seen in our houses being some of them. And also issues around children being part of the witnesses, the intimidation that comes with that, or children being victims where there's property grabbing, inheritance issues, as was put forward by Judge Maria. Those are some of the issues that we need to be discussing, what the root cause is, so that we can address that to facilitate for children not to be in conflict with the law. And also the use of the legal jargon to communicate with children. We need to get to a place where we are saying child-friendly justice system. Even the language, it needs to be toned down to a level that a child in a specific jurisdiction can comprehend what we are talking about, and also recognize diversities within the child cohort. We know that when we look at issues around early childhood development, there are issues around who develops faster, what are the contributing factors to that development process, and therefore we shouldn't take children as a homogeneous group, but rather recognize that they are different, and that if we were to really ensure that there is access to justice for children, then we need to be recognizing that diversity within the cohort. And also the involvement of stakeholders. As civil society organizations, we feel that we need to be involving all stakeholders when cases or issues around access to justice come to the fore. Stakeholders like social workers who can help us to prepare children for court and provide the psychosocial support that is needed when one is involved in such matters. And then involvement of parents. We know that in some African countries, especially where children are a victim of certain violations, we find that parents are actually the people that are causing cases to be withdrawn from the police or to be withdrawn from the stage at which the case is progressing with the intention of addressing it at home. And that in itself then means that access to justice for that particular child is not met. And we need to also ensure in some instances where parents really are not interested that they can become part of the process for them to appreciate their role in holding or supporting their child to get justice. And also in instances where children in conflict with the law are taken to juvenile centers, we find that some of them really are not child-friendly at all. In fact, some of these centers are not habitable, such that a child who is there is now even more depressed, has anxiety attacks and all of that, which then affect their mental health status. And these are some of the issues that as civil society organizations, when we say the theme comes at the right time where we're grappling with a lot of these issues, is on the basis of what we are currently experiencing on the ground as we provide services. But we do pledge as civil society organizations that despite these gaps and these challenges, we'll continue to contribute to the body of knowledge. We'll utilize research findings as they are done by various bodies, including yourselves as the center. And we'll ensure that we can utilize these findings to close the gaps that are being experienced at regional, at national levels insofar as access to justice is concerned. And we'll continue in our role to educate and empower service providers, both as children as rights holders, but also duty bearers in ensuring that it enhances child-friendly services at those levels. And we'll continue to hold governments accountable, particularly governments as they have signed the African Charter on the Rights and Welfare of the Child, to ensure that every provision therein is actually a provision that is being adhered to and is facilitated for practice or interventions to be done as provided. And we work with all stakeholders to facilitate meaningful involvement of children in aspects that affect them, and ensure that there is, of course, access to justice, and that we can learn from each other for best practices in making the judicial system functional. And we also would want to be held accountable as civil society organizations in the various interventions that we are promoting, so that in turn we don't find ourselves as the people that are violating children's rights, but rather that we safeguard and protect the rights of children in order to ensure efficiency and effectiveness for children to grow up in an Africa that is fit for children, and make sure that these children then become responsible adults tomorrow who can take this continent to greater heights and be able to do business with other continents on the world. Thank you so much, Nkatha, and this is the civil society perspective on the theme.
Thank you very much, Felicitas. I had started waving because I wanted us to get into the position where we get into discussion. You've raised some very pertinent issues, and I think some of these pertinent issues will probably recur in the conversations. I already see that there's quite a lot of engagement happening on the chat, and some of the questions I see are, some of you are responding, some of them I think we'll take them here. I would want to just start us off by highlighting some of the issues that maybe we may want to and we'll ask the panelists to respond to some of the questions. I'm sure you may have noted the ones that are coming up on the side. We will pick up on those. So one of the issues I haven't spoken too much to, and which is relevant to this conversation. If I may request people to please mute your mics. We have some interference, I'm not sure from where. One of the issues that we haven't addressed ourselves much to, and which is very relevant, is the issue of COVID-19, the pandemic and its impact on access to justice for children, particularly the consequences of the measures that states have taken in response to COVID-19, and how that is affecting how children are able to benefit from justice mechanisms. The key questions in that area is, have children had, do children still have the opportunity to access justice systems when these systems are closed off because we are social distancing? That is one question that we need to think about. The second thing to think about is what have we learned about the exposure of children to violence and to violations during this period, and the fact that in some of these cases, the justice mechanisms are helpless to help children because that access has been broken, and yet the violations continue to still manifest. And this has actually been a period of heightened abuse for some of children, particularly within their homes, where the rates of cases of domestic violence have highly soared. And I'm sure that maybe some of you who are in the front lines would know the manifestations of violations that are taking place. As someone else may also have mentioned, I think on this forum, we are also seeing cases of we need to think to address our minds to the long-term impact of the pandemic and how that is going to affect access to justice for children, particularly think about, you know, girls who have been violated during this period and what their choices, what their options are in the longer term. People who have had to endure sexual violence during this period, people who have been taken out of school, because the longer girls stay out of the education system, the higher the risk that they'll be diverted to other areas such as early child marriage or pregnancy. So COVID-19, in essence, the pandemic, that context, emergency, what do we think about that and access to justice? So as the panelists respond, I hope that some of us can address our minds to that. The second issue that I would want to raise is in relation to informal justice mechanisms. This is a question that has been raised over and over in the comments. I will also, again, leave it to panelists to address, but if there's something that remains to be said, access to justice, when you're talking about formal justice mechanisms, the simplest way to explain what you mean is to refer to those institutions that are established by law in a country, by statute, and therefore that are regulated within the formal legal system. And so this would range from the law enforcement, which would start at the police, it would go into the judiciary, it would go into prosecution, and it would also cover corrections. So when children go through that process, we refer it to as going through the formal justice system. However, outside of that, there are many other justice mechanisms that children can access and which they routinely access. And those, for instance, include access to justice through what Musa said, traditional mechanisms, like, you know, in rural areas where you have chiefs administering traditional chieftaincies. However, we also have chieftaincies that are established by statute, such as administrative processes. That is also another avenue. There is also the avenue of religious institutions and religious procedures. So that is also another mechanism. And there are also mechanisms that may not be religious, but they may be socially established, such as where a community has come together, maybe with the help of an NGO or another entity. Maybe it's a process endorsed by the state, but it's not judicial. It's just a process that allows people to be able to resolve disputes. So they can take various forms. And that is really what we are referring to as informal justice mechanism. The space is wide. Some of them are semi-regulated, others are not regulated at all, others are completely informal. Some apply, you know, traditional norms, others in some cases may apply modern norms, not necessarily norms, but modern procedures such as arbitration and mediation. So that would be the broad scope that we are talking about. The final thing that I want to highlight, and which we should also apply our minds, is that as we have this discussion, that we apply our minds to the plight of vulnerable groups of children. Okay, so within children as a group, but even within that, we also have we have children who are especially vulnerable because of certain factors, such as children with disabilities. And children with disabilities would, for instance, when Professor Skelton was speaking about access, would have a higher layer or would have an extra layer of access needs. And it can be physical, depending on the nature of the disability, but it's about access to the proceedings, one, but also access to the facilities. So there is the access to facilities, which is easy for us to, you know, because we can think about how a child with a disability is not able to access the court. But we also need to think about children with psychosocial disabilities, who maybe even the behavioral disorder that is causing them to be in conflict with the justice system is actually, you know, it's a disability, or it's a health issue, it's a mental health issue, and the justice system is responding to it as a justice issue as opposed to a mental health issue. So how do we respond to that? How do our countries think about and address children in such circumstances? How do we nuance our system so that it's inclusive of the diversity of children, of the diversity of children's capabilities, children's awareness and knowledge, children's living arrangements, such as if children living on the street, are they able to access justice in similar way as children in other circumstances? So really, this is just to open our minds to the vast nature of things that we still have to discuss in the next few minutes. I would want to use this opportunity to put it back to our panelists. Having seen the issues that have been raised on, I believe we all have access to the chat, as well as some of those issues that are raised, that you can come back and maybe reflect on them. And so I would go back to our first panelist, Judge Maria, if you would have the floor, and if you can speak to some of the issues that you may have identified. We cannot hear you, you're muted.
Thank you very much. And I think I should start with the issue of COVID-19 because as someone who deals with cases in court and directly affected by this COVID, what happened in terms of the justice system, how it has actually been affected, and whether the question is valid that, whether the question is valid or not in terms of how children are affected by the COVID-19, it is real. I'll give you an example of Zambia and I'm not a magistrate, I'm actually a high court judge. So that should, I would want to clarify that because as Professor Ann was saying, there are certain things that happen in the magistrates' courts that do not necessarily happen in the higher courts. But having said that, the magistrates' court in Zambia closed down in, I think, the second week of March. And eventually the superior courts followed in the last week of March. No one had any access to courts until 1st of June, when the courts opened up. And in the meantime, what was being said was that only urgent cases would be dealt with, and the criteria for urgent cases was given. But the problems did not stop because the issues of domestic violence against children are increasing because suddenly people are forced to be in a certain space that they have become more intolerant of each other because they're quite confined. Now, the point that I want to make is that if you like, during COVID, the right to access to justice has more or less been suspended because people are not accessing at least the formal justice sector in the way that they would have wanted to. And then also now what is being developed are these forums where electronic or internet forums where people now are being told that if you're going to access the courts, then you need to electronically file certain documents, or you'd need to not be heard. Your lawyer would come, maybe you deal with a case on the basis of affidavit evidence. So now that is a very big challenge because you have to look at the population, you have to consider how many people can access such facilities, and you actually have to look at how many people are being processed, because even in terms of who can access court, in terms of the criminal justice system, again, let me talk about that. There may be 2 or 3 cases allocated in a day, and out of those 2 cases or 3 cases, maybe you can only hear a total of 4 witnesses. Whereas in the past, you'd be able to process maybe even 20 cases or more, depending on the type of case, because some of them are fast track, some are a question of sentencing, some are a question of admissions of offenses, and in that regard, you'd not really have to spend too much time in court, and maybe very few cases which are coming up for trial or confirmation or etc. So the impact of COVID on courts or access to formal justice is real. And a lot of people have been excluded because of the systems that have been put in place on how you can actually access the formal court process. Now, let me also quickly remark on informal justice. I had given an answer, but essentially, as you say, these forums or courts, if you like, traditional courts or religious courts or anything that is accessed outside the court system. It can also refer to any out-of-settlement negotiations or settlements that people would arrive at in settling their disputes. Why informal justice is a big issue is because it affects a lot of people, especially in rural areas. I once had this case that had been escalated to the High Court because a traditional chief held someone in contempt of court and detain that person at his palace or at his premises for more than 6 months. The person had, because they also have some sort of traditional cells. So imagine that person being kept there because he insulted the chief's child. And, you know, these are people who are very powerful, and these cases rarely permeate to the levels that they should, because there's this breakdown in communication between the formal and informal justice sectors, and even the type of personnel that they employ. These are village, maybe community groups that enforce law order, and this becomes a very big problem. But I'd like to come back to what Musa said, what Dr. Musa said, when you're saying that the justice, I mean, like when we're looking at child-friendly justice systems, that it has to be domesticated, and which is true, and I agree with that completely. But at a continental level, you need, even at a global level, you need a certain basic minimum. And that is what I think most of these treaties or laws have tried to establish. But then you can't just leave it there, because there are a number of emerging issues, and children in conflict are a special group, and they are really in real problems. But you cannot have very specific treaties or child-specific legislation without setting a basic minimum. So what has happened in terms of whether it's formal or informal, what is very important to bear in mind is that there's a standard by which countries should approach access to child-friendly justice. And then from there, it will now be domesticated according to the specifics or the problems or circumstances that different countries face. And lastly, to underscore what Professor Ann said, and this is very important, she said two things that I think that, in addition to the many wonderful views that she exchanged, that when we are looking at access to justice, we must start from the lowest level of society. If it's a formal justice system, you're looking at magistrates' courts. If it's the informal justice system, you're looking at these same traditional courts or religious bodies that we exercise power over certain or citizens, or if it's a formal system, or under subjects in a traditional or religious setting. It's very important that we tackle the issue of access to justice at the lowest level, because that is where, and I reiterate, a lot of injustice happens. When you're approaching the formal system, and for those who can, it will be those who can do so because they know what the issues are or are settled, or children who are coming into conflict with the law. And that's the one-sided affair, with most of these treaties emphasizing on juvenile justice. It's time that we removed the emphasis from juvenile justice and look at other forms of access to justice, because they are real and they are there. And courts, whether be it by their personnel or by the judges or their infrastructure, can only handle a certain number of cases. And most importantly for me, and as I conclude, it's also a question of making sure that the highest courts in the land, or the superior courts, engage in strategic litigation, strategic judgments that can enhance the issue of access to justice on the continent. I end here for now. Sorry for taking long.
Thank you very much. No, we appreciate your points. Unfortunately, we are struggling for time, but the points are so good, yes, and we want to keep them on. So I will request Professor Skelton to come back in or maybe respond to some of the issues you've seen, or, I mean, it's open to you.
Yes, certainly. On the COVID-19, I think it's been very interesting because it's forcing us to think about the limitation of children's rights during a crisis like this. What is reasonable? Now, the Committee on the Rights of the Child did issue a statement on this and acknowledged that there are, in a public health crisis like this, obviously everyone's rights are limited to a certain extent. But that to be human rights compliant, limitations must be temporary, they must be time bound, they must be reasonable, they must be justifiable. And I think when we look at what has happened on the continent, after all the dust is settled, we will see that in many instances, these things were breached. Even in South Africa, where I would say the government's regulations on justice were quite often recognizing the importance of children's cases needing to continue. One thing that they did in the early stages was that they decided that children who were in detention awaiting trial would not be brought to court. And this is in violation of our own law, which requires children to be brought to court regularly. Now, at the beginning of lockdown, when we were talking about 3 weeks, that might have been reasonable and time-bound and so on. But as that time extended and extended, that would no longer have been justifiable, in my view. Fortunately, government was sensitive to proposals that were put to them, and they did change that. So I think this shows as well, sometimes it's not necessary to go all the way to court, just writing letters to ministers and so on can also have that impact and can also provide justice for children. So I think there's a lot still that we need to unpack and think about for the future, because this might not be the last big crisis that we face, and we should be better prepared. I also just want to say there's an interesting case going to court next week here on the right to nutrition for children, because the school feeding scheme has been closed down for 3 months, and the minister originally promised that she would start feeding all children again, even though phasing in of scholars is happening, and then she decided not to do that. So there's a court case pending, and this is another example of access to justice being used to achieve rights such as a basic right to nutrition of those very vulnerable children who are actually without food.
Thank you very much, Professor Skelton. I will ask Musa, who also has quite a number of questions on the chat. Unfortunately, because we have 2 minutes to go to the end, and we cannot exhaust this, I am going to beg the indulgence of panelists to go up to 5 past so that I can give them 2 minutes and then we conclude. Musa, you have 2 minutes. Sorry.
Thank you. I have many responses from the audience. Thank you so much. The first one is around how we deal with children who have been associated with terrorist groups or armed groups. I think that's an important issue to raise. With the leadership of Professor Benyam, we are undertaking a continental study on terrorism, the impact of terrorism on children on the continent. I think we are acknowledging that this is a gray area on the continent that needs lots of interrogation so that we can have interventions that are informed. So we acknowledge that. But at African Union level, in the Peace and Security Department, there is a guidance that has been provided by the Peace and Security Council through a manual they are calling the disarmament, demobilization and reintegration, which speaks to how children who have been found in such circumstances are dealt with. I was talking to my colleague Tuape, who is part of the multi-task force, joint task force who is based in Chad. He's saying many countries in that region have come up with standard operating procedures on how to deal with children who have been captured, but who have been associated with terrorist groups in courts also, because it's a contested issue. And I think there's an issue of the cost implication of ensuring that the justice systems are child-friendly, adapted to the context of children. I will throw it back to the participant to say, should we be concerned about the cost of doing the right thing for the durability of peace, for the durability of the quality of childhood for our children? I think the cost should not be the issue that we should be concerned about. The issue we should be concerned about are the basic fundamental principles to ensure that we have a quality childhood for all children on the continent. Suffice also to say that the African Charter on the Rights and Welfare of the Child normatively does not provide for progressive realization of these aspects that we're discussing, which is an interesting aspect because it places immediacy and agency for the realization of children's rights and also for quality access to services such as these that we are discussing. I think that's important to acknowledge. I will skip the other issues that were comments and go on to talk about the COVID-19. I'm sure I'm left with 30 seconds. I think in the conflict setting, sorry, in conflict setting, COVID has done three things. Number one, the closure of borders as countries are trying to contain the virus. Whilst on the other hand, conflict is still ongoing in DRC, like I indicated in my remarks. You will find then that movement of people who may be wanting to be running away from conflict to safe and secure areas is not happening as it's supposed to because of the closure of borders. But if it's happening, people are crossing borders illegally, which comes again to issues of asylum seekers and refugees, people who have crossed borders without proper systems in place. The second aspect is that closures of schools, we are seeing now on the continent that the lockdowns are easing up, but closures of schools, for us, schools are an early warning system for conflict and also for basic child protection. So when schools are closed, we are not in touch with what the sentiment, with the fermenting grievances that may be within a community compared to when they are open. So this aspect compromises our early warning system for conflict to make sure that children do not, we are not surprised by what's happening there. The last aspect is the triple barrel jeopardy, as I call it, of conflict, of COVID, and in the context of DRC, Ebola. Ebola is more pronounced as we speak.
Hello, everyone.
No, I don't know who is speaking. We can hear. We are fine. If you're not speaking, kindly please mute your mic so that Musa can finish. Musa, please proceed.
Okay, so I was concluding by saying in some of the contexts in Africa, like DRC, it's a triple jeopardy for children because they are dealing with COVID, they're dealing with conflict, and now Ebola has resurfaced. And there are many cases that are there. So this is affecting a whole lot access to justice for children and the quality of life they are living in. And I totally agree with Honorable Justice Maria on establishing basic minimum principles that we anchor our models for child-friendly justice as we adapt it to different contexts. I'm in agreement with that. Thank you so much.
Thank you very much, Musa. Felicitas, in a minute. Sorry. Felicitas? Felicitas, we don't hear from you. We will be concluding. I don't know if you can hear us. Okay, I think we seem to have lost Felicitas. I don't know what happened. In conclusion, we will be, okay, Felicitas, did you come back? Okay, you have a minute, please. Okay, Felicitas, we don't hear you. So I am inclined to finish if you're not able to say something, which is very sad. Are you there?
It's muted to the side.
Okay, we can hear you now.
I can't hear a thing.
We can hear you. Okay, it seems we are not able to connect with Felicitas. So just to conclude, I think you can see a poll on your screen. If you can kindly respond to that as well. We have had a very fruitful discussion. Unfortunately, I feel very bad because the issues are so engaging and we would want to continue to have this conversation. But there are so many events happening around the Day of the African Child today. And I acknowledge that some of our panelists are also actively involved in the other sessions of those events, particularly the commemoration that is being led by the Secretariat of the African Committee of Experts. and some of us will therefore be joining that conversation soon after this. So that would mean that we don't have a lot of time to engage. However, just in a manner of concluding, I would want to say that even on my own part, just taking notes and listening to this conversation, I'm amazed at the breadth of things that we would have that have come up in terms of the issues that we need to pay our attention to procedurally, but just the practical things that would ensure that this conversation moves from talk to practice, and particularly in ensuring that national systems become child-friendly in practice. That is, engaging all stakeholders, recognizing and acknowledging the breadth of stakeholders ranging from civil society to social workers, to lawyers, prosecutors, law enforcement, the judiciary, and all those institutions. I also see the centrality of speaking concerning informal justice mechanisms. I think that's a conversation that we really need probably to have a follow-up on, because it seems to elicit a lot of interest. I think the conversation on children and armed conflict also seems to be, something that we are not able to delve into the depth in this moment, yet there is a lot of things that we would want to unpack, particularly the relevance of principles and the relevance of standards that we espouse regularly in access to justice terms, and what that means in a context that is not peaceful, that structures have collapsed, and in the nature of conflict. And then there is a whole conversation around children who are not in conventional home settings, children deprived of liberty, and how even in that context, if there are certain violations, are they themselves in a position to access justice for those violations? Thinking about children with disabilities, children suffering psychosocial disabilities, behavioral disorders, how do our systems respond to those? Children with sensory disabilities, do we have support mechanisms and support systems to enable them to engage with the system? We are talking about the biases that affect girls differently from boys in accessing justice. How do we address those? How do we bring on board children living in rural areas as we think through the issues that we are talking about in access to justice? So really there is so much that we would want to continue and unpack, but we are not able to do that. We are hoping that we'll be able to do it when we join the conversation with the African Union. You can go on the website of the African Committee or the Twitter page, you will see the login and you can follow. I don't think it's a strict registration as it is for ours. Otherwise, from my side, it's really a word of a huge thank you to everyone who has participated. To the panelists, thank you very much for your time and your valuable contribution. To our team on the ground supporting this, Yolanda, Tiruna, Simpiwe, and colleagues in the background that have made this possible. And to all your participants who have stayed and continued to have separate conversations. We hope we can continue this conversation, so let's take it over to Facebook and Twitter. You can reach out to us when this, the recording and other, the recording of this webinar goes live. You can also Twitter at us, you can follow us, and we are happy to continue speaking about this. Thank you very much. Have a lovely day. For those who are in South Africa, have a lovely holiday. And yeah, thank you. From our side, we sincerely appreciate your time. Thank you very much.
Thank you very much.
Thank you.
Thank you. Thank you.
Thank you. Bye.
Thank you. Remember to attend the next one, as Dr. Nkatha said.
All right.
Thank you. Bye.
Going there right
very
now.
much.
Thank you.
Thank you. Bye.